So I should note that I was really prepared to present on part 3 and 4, armor that on that more. Since Prof said we should align with the introduction, I'll just bring myself back to earth. So our topic is on. Please let me know if I need to maybe share my screen or show my video.
No, you can share your screen because it's not enabled, so you can just speak to the paper.
Okay, thank you. So our topic is on property risk and title in sale of goods transaction. Before going into sale of goods transaction, and we must note that the principal law that guides sale of goods in Nigeria is the Sale of Goods Act of 1893, which is the Statute of General Application, which we got from England. And that particular, before going to that particular act, provides some definitions. It defines what property is, but it does not define title and it does not define risk. But it defines sale. So before jumping the gun, let me just start from the introduction to make that clear, because I know Prof was particularly concerned about the definitions. That our paper explores the legal principles governing the transfer of property, risk, and title. It's very important that we note these three: the property, risk, and title in sale of goods transactions, especially as it relates to the general provision, which is that really you cannot give what you do not have, which we all know as the Latin principle of nemo dat quod non habet. And then the exceptions that have been provided for in this act, the Sale of Goods Act, and even in other, by comparative analysis, in other jurisdictions also, the exceptions that have been provided for that in order to protect a third-party purchaser and to ensure economic certainty. And then our paper concludes by arguing that the Nigerian courts, although generally favoring the formal rules which is laid down in the Sale of Goods Act 1893, it would do us well if we evolve according to international best practices, what is applicable, using the treaties that are available, and using what is applicable in UK, if we can evolve from just applying the provisions of the law simpliciter. The sale of goods, as we all know, is one of the most fundamental transactions in commercial law. It is something that occurs at both the domestic level and international trade. Sale of goods can go from something as simple as going to the next door malam to buy toothpaste, or a multi-million-dollar complex deal that involves shipments, that involves the transfer of intellectual property across borders. So this sale of goods is at the heart of all that. It just involves the exchange of consideration. It involves the transfer of property, of title, and ultimately of the particular delivery of possession of the subject matter of the sale. So at its core, such transaction involves transfer of ownership between point A and point B, which is usually the seller or sellers and the buyers. However, determining the precise moment at which this transfer occurs and concurrent with the transfer of property goes the transfer of risk also. Determining when this particular moment occurs is always not straightforward, and it becomes very important, especially when we are thinking. It becomes very important when we consider the fact that goods can become missing, they can become damaged, and they can become stolen. So who is entitled to take benefit of insurance, for instance, that has been taken on goods that even though have been sold, have not reached the buyer and have been lost in transit. So these intricate details are hinged on determining if transfer of the title and property or risk has occurred. Now, the distinctions between these three terms, property, risk, and title, becomes very important in over liability for damaged or lost goods. And then, so conceptual clarification. What is property? Property is defined. If you look at Section 62 of the Sale of Goods Act, property is defined as the general property in goods and not merely a special property. This does not help us in the light of sale of goods when we are trying to conceptually delineate when each of these events occur. But however, we have said that we have borrowed from the Oxford Dictionary of Law, and we have defined property as anything that can be owned. Anything that can be owned. Okay, and transfer of risk. What is risk? I mean, we all know risk. Risk means who is going to bear liability for something that occurs. Transfer of risk is the passing from the seller of property to the buyer of the incidence of the loss if the property is damaged or destroyed or lost. The Sale of Goods Act, the one of the UK 1979, which has been amended by the 1995 English Sale of Goods Act, provides that unless it is otherwise agreed, goods remain at the seller's risk until ownership passes to the buyer. After that, they are the buyer's risk, whether or not delivery has been made. This is also reflected in the Sale of Goods Act 1893, which we will see as we proceed. Another important term is delivery. Delivery is the transfer of possession, because really, why are we even talking about sale of goods if it's not really to transfer something to another person? And because we are talking of sale of goods, we are talking about goods, not services that are provided. The transfer of possession of a property from one person to another is delivery. Under the Sale of Goods Act, a seller delivers goods to a buyer if he delivers them physically. If he delivers them physically, or if he makes a symbolic delivery by delivering the document of title to the other person, or if he has other means of control over such goods, such as having the keys of a warehouse in which they are stored. So you deliver the keys to where these goods are. Or if a third party is holding them, acknowledges that he holds them for the buyer. So this can be constructive delivery. Now, Sale of Goods Act 1893 years does not leave us wanting in the definition of delivery. It defines delivery as the voluntary transfer of possession from one person to another. So we understand that possession is also very important as we're talking about ownership. Then the term possession to rings through everything we are saying. Then there is the Nemo, that's called non-abet, which is no one can give what he does not have. The basic rule is that a person who does not own a property cannot confer it on another except with the true owner's authority. Now, there are exceptions to this rule, which we expatiated on in our paper, and some of them include selling under statutory powers. For instance, when the government sells maybe hijacked cars, right, and an auction sale, the government really is not the owner, but they are under statutory power to effect such a sale, and such sale is as good as it's a valid transfer of title to the third party purchaser. And cases where the doctrine of estoppel prevents the true owner from denying the authority of the seller to sell, especially when the owner has represented the person selling as an agent of his. So sale of goods is also one other term to discuss. And sale is defined in Sale of Goods Act 1893 as a bargain and a sale, as well as a sale and delivery. Sale of goods is a contract by which a seller transfers or agrees to transfer the ownership of an agreement in exchange for what is usually monetary compensation. If the ownership is to pass at a future time, then the contract is called an agreement to sell. They are usually implied terms that goes with sale, but that's not what we're talking about. So legal framework and doctrinal analysis, I'm already in part 2 for those of us following via what we shared. The Nigerian legal framework governing the sale of goods is substantially derived from Sale of Goods Act 1893. Then it provides fundamental definitions and rules for determining the passing of property, risk, and title in goods. So property and title are used interchangeably. Property and title are used interchangeably to mean that ownership quality on the particular goods that is being exchanged, that is being sold, while risk is who bears, why risk is, as we have explained earlier, who bears the liability for incidences of loss. So property/title and risk. So the Sale of Good Act 1893 provides foundational definitions and rules for determining the passing of property, risk, and title. One would think, should property not go with risk? But as we would see later on, there are times when risk passes before property, and there are times before title, and there are times when the title passes before the property. So our act it distinguishes between different categories of goods. We have specific/ascertained, and we have unascertained, especially when it affects ownership and risk that passes. And our act also codifies the nemo das non quod abet rule while providing for the exceptions. So according to the Act, general property in goods passes when the parties intend for it to pass. So when the intention is not expressly stated, the Act further proceeds to provide default rules in section 16 to 20 that would determine this moment. So the general rule is when do parties intend for title and risk to pass. Usually you would see that clearly stated in their from their overt actions or clearly stated in the agreements of the sale. But where this is not provided, the Act provides for default fallback in section 16 to 20. Specific and so for specific and unascertained goods, so such as things that are in specific and unascertained goods. Sorry, no property can pass in unascertained goods. Thus, for proper ownership to transfer, no goods must be either specific or ascertained. And we can see that this is actually a common sense principle. I mean, if you cannot ascertain something, how can you say you have gotten it? So for specific goods that are in a deliverable state with unconditional contract, property passes when the contract is made unless a different intention appears. So this also rings true about how the Act is very concerned about intention. So once the general rule applies and parties have intended and it is very overt and clear what they intend, then that intention is meant to be enforced by the courts, by the parties themselves. And however, where goods are not yet in a deliverable state or require some actions by the seller to make them delivery, property does not pass until those conditions are fulfilled and the buyer is then notified. So maybe if you are meant to buy something from a tailor or somebody who sells wares and the person is meant to do something to make it before you buy it, property doesn't pass. So you cannot say, even if you have paid the property on that person, except you otherwise intend something else. But property does not pass until those conditions are fulfilled and the buyer is notified. For unascertained goods, property only passes when the goods are appropriated to the contract with mutual assent. This rule is particularly important in commercial sales involving fungible commodities like grains, oil, or other bulk goods. So, for instance, in Reweight, a 1927 case, a buyer paid for half of 500 out of 1,000 tons of wheat, but failed to obtain legal title because the goods were not segregated. Although, as at now in England, as going by the 1979, 1975, and the 1995 Act, this has changed a bit, such that if you can say that a bulk has been ascertained, property will pass. But the common law rule, which is still applicable in Nigeria, is that as long as it is not ascertained, even if you have paid for half of the tons, because it's not segregated, it will not pass. Also, in Koskari's Motors and Motors Zinwa, the rule has been enforced that a buyer cannot obtain better title than the seller possesses. These are codified in section 18. So you cannot obtain, that's in section 20. You cannot obtain 21. You cannot obtain better title than what the seller possesses. That is the codification of the nemo that called non-abet common law rule, even if payment has been paid, unless the goods are properly ascertained and appropriated. Then we have sale or return and delivery terms. So for agreements that involve a sale or return basis, property does not pass until the buyer overtly communicates that he accepts it or so he adopts it, or he retains the goods beyond the agreed period, and if no period is agreed, beyond the reasonable period. This is also recognized in our Section 18 Rule 4. So if you check Section 18, there are a couple of rules. There are about 5 rules expressly stated. That's what we have been trying to explain. Then transfer of risk. Risk as a general rule passes with title provided for in Section 20 of the Act. 20 says that unless otherwise agreed, the goods remain at the seller's risk until property therein is transferred. But when property therein is transferred, the goods are at the buyer's risk. So property, according to SOGA, except agreed otherwise, transfers with risk transfers with the property. And we know that later on in our paper, we talk about when parties may decide to let risk go first before property, and that is in some international shipping transactions like the CIF costs, like CIF freight agreement that says that, oh yes, the ownership will pass now, or the ownership will pass when the property lands at the buyer's ports of destination, but the risk passes already. So if anything happens in transit, the risk passes, even if so has not passed. These are not usually common, but they are things that our lawmakers have envisaged. They are things that happen in general day-to-day transactions, and it is provided for. So risk and property can be separated by agreement or implication. Okay, I'm already in page 9, so I don't know if I should maybe finish.
No.
Okay.
Yeah, I think we are done once you have gotten to page 8.
Oh, okay. Sorry, my apologies.
So that's all right. Can we discuss the paper in 5-10 minutes? What is our purpose? What's our objective of looking at veering into sale of goods law? We are still exploring the various usage into which the term ownership, possession, property, etc. are used. And we just thought that the Sale of Goods Act might be a way of looking at the different contexts in which those words can be used. The Sale of Goods Act talked about delivery, which is physical. So that can go for possession. You would think that once the buyer has possession of the chattel, once the buyer has possession of the chattel, he has acquired ownership or property of it. And you would think that the opposite of it is that before the goods or the chattel is delivered to him, he does not have ownership. But Sale of Goods Act has demonstrated to us that those are fine points of contract and of property law. So, and that's what we saw from, I think, section 16 to, is it 19 or 20 of the Act? Okay. So all of those rules are trying to tell you that it is not always when a person has possession that ownership inheres in him. There are occasions when he will not have possession, yet ownership will be deemed to have inherited in him. for other purposes. So, for example, when the section was talking about ascertain and unascertain goods, the usual example of unascertain goods is the owner of a warehouse has say 300 or 500 bags of cocoa, or sorry, has say cocoa worth say 100 kg. Okay, and somebody wants to buy 30 kg out of that 100 kg and has paid him money. Okay. Where the rule is that risk follows property. It is important to determine whether by merely paying money and accepting the money for 30 kg property has passed. So the Sale of Goods Act is telling us that 30 kg out of 100 kg is an uncertain good. So assuming after being paid, thieves burgle the warehouse and pack all the cocoa from there, what is going to be the correct position regarding risk? Whose cocoa will we say was stolen? Is it the 30 kg? Will we regard it as the loss of the owner of the warehouse so that he will then have to refund the money because consideration has failed? Or will we say that as at the time the entire cocoa was stolen, 30 kg of it has been bought, so they share the risk as well as the property. So, but the relevant section is telling us that because the goods were uncertain goods, property has not passed. Okay? On the other hand, even if the buyer has not paid, but the seller has accepted to reserve 30 kg for him, and with his permission, had packed the 30 kg in a number of sacks, put them in one corner of the warehouse, and informed him that these are your bags of cocoa. We have measured them. They are equal to the 30 kg you want to buy. Then either before the buyer pays or before the buyer comes to take physical delivery, in other words, before it comes into possession, something happens. The relevant section will say that property had already passed to the buyer in that circumstance. And so he bears the loss, whether the cocoa was stolen or whether fire gutted the warehouse and the cocoa was lost in the inferno. In all of these circumstances, the buyer, who is here to take physical delivery, will nevertheless be deemed, it will never be deemed that property or ownership has passed to him. So the fine distinction between physical delivery, which is transfer of possession, and property, which is ownership, is what we want you to take note of in the context of the usage of the word property. Then in the later sections, I think from section 20 to 25, you will find that the legislature was using the word title. And the legislature started with the general principle of nemo dat quod non habet as the general rule. And then between sections 21 to 25, he created relevant exceptions when nemo dat quod non habet may not apply. Okay? Including, for example, the case of somebody who had acquired or bought at a market of art. Okay? And somebody who is stopped, okay, etc., etc. All of those exceptions were listed. Our concern is not to go into the details of the exceptions, but to interrogate the use of the word title in those sections, as opposed to the use of the word property in the previous sections. Property, we can easily say, refers to the rest itself or ownership of the rest. Is it different from title? Is it different from title? A jurisprudential analysis will show that, in effect, title and property simply means ownership. But in the context of the Sale of Goods Act, you can draw a distinction between the use of the word property and the word title. The legislature had consistently used the word property if the dispute is between the seller and the buyer. If the dispute is between the seller and the buyer, and for purpose of determining who bears the risk, or whether ownership has changed, the legislature decided to use the word property. But you will see that in the sections beyond section 20, where the word title has been used, we are now talking about competing claim of ownership. So, which does not derive from a contract between the two competitors. So, if what we are looking at is who retains ownership or who acquired ownership between the buyer and the seller, the word property was conveniently used. But if there is no contract in between the two disputants, and the court would have to determine who between them can keep the goods, the legislature devised a neat plan for using the word title. At the end of the day, if you say the title in a thing vests in me, and the property in a thing vests in me, you are saying the same thing. So the word property and the word title would mathematically mean the same. If I am said to be the person in whom property vests in respect of a thing, or I am said to be the person in whom title vest in respect of a thing, in the two contests, I am being said to be the owner. But it will amount to not being enlightened legally to use one in the context where you are supposed to use the other. So the word title, by the use of the legislature, is appropriate when there is no contract between disputants. There is no contract between disputants. So, for example, if you are talking about the warehouse owner has stolen the goods or had bought from a person who stole the goods, whatever, the root of title to the goods was defective. But either section 24 or 25 says the person who buys in a market overt and the warehouse is treated as a market overt acquires title as an exception to nemo that court no habit. So who are the two claimants now? The two disputants now will be the owner of the warehouse, okay? And, sorry, the two disputants will be the original owner of the goods from whom it was stolen, okay? And the person who bought it in the warehouse. You see that in between the two of them, there is no contract. So the word title was conveniently used in that context to depict a situation where there are two disputants as to the ownership of a property, and there is no contract between the two of them. And yet, the task of the law is to determine who between the two of them will be the owner. So you can see the context in which the word title was used there. On the other hand, if you look at all of section 16 to, I think, 20 or 19, as the case may be, you find that we are talking about relationship between buyer and seller. And we are concerned mainly with at what point does the good or do the goods become that of the buyer, so that he would be the one to bear the risk of loss or damage to them. So you can see that when the dispute as to who has the overriding rights or ownership or title is between two persons in between whom there is a contract, e.g. a buyer and a seller, or a vendor and a purchaser. The word property was correctly and conveniently used, okay? But when the dispute as to who owns the thing is between two persons between whom there is no contract, the legislature chose to use the word title, okay? So that is why we introduced the Sale of Goods Act. The motivation to include it in our syllabus or in our course discussion arose when Professor P.K. Fogan delivered his inaugural on, especially on passing of property in sale of goods. And I thought that, well, the use of the word property, the use of the word title is a task that we in jurisprudence class should give to ourselves. And beyond what a commercial lawyer will say. We can help with analysis. We can help with explaining the contextual usage of those words. Of course, Professor Vaughan was delivering his paper as a commercial law professor. So he didn't bother himself with all those definition of terms. But it is our own role to dabble into what does not concern us in the name of, in the guise of trying to precisely define terms and show some of the time that the layman's understanding is not usually the legal intendment. So, any comment or question on this before we move to the next paper? Hello?
No comment from me, sir.
So,
No
can we move
comment,
to the
sir.
next one?
Sir,
Yes?
please, please, what's the implication of distinguishing between the usage of the word property and title?
Is to show that when in jurisprudence we talk about property, ownership, title, possession, etc., their meaning could differ depending on the context in which they are being used. And so, for purpose of a correct legal language, we should understand the context in which we will use either, even though at the end of the day, they may just mean the same thing. Okay? And you may not be able to distinguish between them. For example, how do you distinguish between the word property and ownership? The context of usage will determine which one you use. But whichever one you use in the right context will convey the same meaning. Okay? Which is
sir.
either the ownership of the rest, or you are saying that the highest aggregate rights in the rest is resting in the person who is claimed to be the owner. Okay?
Okay, sir. Okay, sir.
Yes.
Thank you, sir.
Yeah, you're welcome. So let's take the next paper. The next paper, please. That next paper, I've also gone over it. I do not know what part of it I will tell them not to read, because everything they have said is very, very relevant to. It's very, very relevant to our discussion. They are to talk about just 30 and finder's right. So,
Good evening, sir.
let me tell you your time. Let me tell you your time. We want you to deliver every aspect of your paper, but you talk to it. Your paper, we will all go and read. We don't give you more than, say, 25 minutes, so that you can use the remaining time to discuss. Originally, we had thought that we are going to take all the remaining 3 papers in this area, but I don't know whether we can take adverse possession. Or even the one that was short, we ended up using more than 40 minutes on it. So I don't want to, both your presentation and our discussion, I want it to be not more than 1 hour. So I give you 25 to 30 minutes to present. You speak to the paper, please. Don't read.
No problem, sir. Good evening,
How
Prof.
many of you are you around? How many of
Yeah,
you?
so, yes, I want to call out the
Yeah,
names so
well,
that, yes, I want to call out the names so that if they are here, they can answer present for your acknowledgement, sir. Good evening, Prof. Good evening, class. Our seminar presentation topic is on Jus 30 and Finder's Right in the Law of Torts. This is seminar paper presented by Group 6. Anyawu Judith Chidima, please, if you're here, can you indicate? Okay. Emmanuel Eta Tuevi.
Eta Tuevi, present.
Okay. Sule Ayadin Jennifer.
Present.
All right.
Okay. So how many of you will present?
Judith and Judith will be taking up the presentation. Before we start off with the presentation, a brief introduction of what we are talking about. So this our topic is more of it's in the same category as the law of tort. We already know what the law of tort, all about. Undergraduate or must have interacted with it in one way or the other. So our table of contents, we have the abstract, the part 1, part 2, part 3, and part 4. The part 1 gives more of an introduction as to the topic and the meaning of Jus 30, the Jus 30 as a defense in the law of tort. And part 2 talks about the finder's right, the categories of finder's rights, finder and the owner of chattel, finder and strangers, finders and occupants of premises in which the chattel is found, finder and master. Part 3 talks about the foundation of the lost and found, possession as a source of property, physical possession and constructive possession, the extent of finder's rights, reasonable steps to find the true owner, distinction between lost, misled, abandoned properties and treasure trove, exception as well to the finder's rights rule. And then part 4 talks about the application of finder's rights in Nigeria and other jurisdictions, as well as our conclusion and our recommendation. So I'll hand over to Judith to take it off from there. Thank you, sir.
Okay. Good
Please
evening,
speak
Prof.
to the paper. Speak to the paper. You can save time.
Okay.
Yeah.
Good evening,
What is
Prof.
the
Good
meaning
evening,
of
class.
just 30?
Okay. Just 30. This is when the defendant claims that a third party has a superior title than that of the plaintiff. That's just the plain meaning of the word just 30. That's the right of a third party. So just 30, some has posited that it's actually from a Roman concept and is actually used as a defense in relation to torts. So just 30 as a defense in the law of torts. Like I earlier said, that is actually a defense in the area in relation to property. Also, just 30 has several legal applications, including in constitutional law and in the law of torts. Under the law of tort, just 30 can be used as a defense in common law against conversion, detinue, or trespass in relation to a wrong done to a chattel. So the cases in which just 30 can be used as a defense are few, but with one of them being a case in which the defendant has the consent or authority of the real owner of the property to deal with it or access it. It can be used such as a defense. In such a case, just 30 may be pleaded. Another case is where is relation to bailees. Generally speaking, a bailee may assert the title of a third party to defend against a claim by the bailor, whose title the bailee would otherwise be stopped from denying. In the case of Eastern Construction Company Limited versus National Trust Limited, the appellants had a contract with a firm to supply railway ties made from timber cut by the firm. Unknown to the appellants, the firm entered the respondent's land, cut and removed pine timber, manufactured ties from it, and delivered them to the respondents. Lord Atkins, when he delivered the judgments of the Privy Council, he stated that the setting up of a just 30 as a defense, setting up a just 30 but as a donor or assignee of the right of oneself. This means that by accepting fees for the ties from the appellants, the Crown had retrospectively conferred its title authority upon them. Evidently, it is able to conclude that the same result would be occurred if the Crown had evicted the respondent from his paramount title. Here, justice was upheld. Also, in Nigeria, the rule in Nigerian law is that a defendant sued for trespass to land cannot plead justity and justify their trespass by showing that a third party had a better title or right to possession than the plaintiff in de facto possession. Because it is generally believed that one in possession has a better title, except the defendants, that's the second person, can prove that he got except he can prove that a third party has a better title to that of the plaintiff. In a Nigerian case, is Oguche versus Iliasu, where they explain the law as this: a person can defend against a trespass claim if they have the right to possess the land, or if they acted with the permission of the person who has that right. Then, to successfully raise the justity defense, the defendant must, one, show the third party's rights. That's to show that the third party has a superior right or title to that of the plaintiff. And secondly, prove plaintiff's lack of interest. Application in the United States. In the United States,
leave that, jump that.
Okay.
We will read that one on our own.
Okay.
Do you understand?
Then we now have finder's rights. The concept of finder's rights, that's the right of an individual who finds lost or abandoned property. Anybody who has a finder's right over a lost property has an obligation in law to take reasonable steps to trace the true owner of the lost property before he can lawfully claim or exercise rights in relation to that property. However, there are exceptions to the general rule, which I just stated. One, we have a trespasser. A trespasser who finds something of value on someone else's property cannot claim it. Secondly, employment or agency. And thirdly, property type. A finder is one, like I said, a finder is one who has found a lost item. At common law, finders have certain rights that have been discovered for several years within the sphere of the law. While different jurisdictions have different principles, there are some general ideas that seem to work well with this situation. A finder in possession has a valid right against the whole world except the true owner of the property. When the true owner shows up, then you know that the finder has no right in relation to that. However, the courts have faced significant difficulty in deciding who gets to keep the lost item that has been found, and have generally followed the principle in which lost items can be kept by the finder, except when a better title has been raised. We now have categories of finders. According to Black's Law Dictionary, a finder is one who discovers and takes possession of another personal property. A finder is one who lawfully comes to the possession of another's personal property, which was lost before. In Parker versus British Airway Board, it was the law, as in 3 rights were laid down in relation to that, and the obligations of finders as follows. 1, the finder exercises no right unless the item is abandoned or lost. You must have found something. If the item is not lost, you cannot be said to be a finder. Secondly, a finder must take the item under their care to gain rights. It must be in your possession. Thirdly, if the finder takes it into their care with dishonest or in the course of trespassing, then they acquire only limited rights. Then we now have then the fourth one, the finder only acquires rights against the whole world as a whole. The true owner and anyone with prior interest to keep the item that existed when the finder took it into care have better rights to them. That's the owner of the property has a better right to the finder when he can actually prove that he has a better title. Then we now have finder and owner of a chattel. In the case of abandoned property, the finder has the right to claim it over the owner, who by definition has relinquished the goods. Because if the goods are in possession of the owner, a finder cannot be said to be a finder of any property. It must be lost. There's a typical example. Okay, let me just give a general example. A typical example is a couch left in the corner of a street. in such a case, it is presumed that the couch has been abandoned because it was left on the street, and whoever comes across it is deemed to be the owner. In contrast, for misled or forgotten goods and property that is strictly lost, the true owner's rights are indisputable. We now have finders and stranger. A stranger is somebody who, before the discovery of an item, had a relationship to it or to the locus inco. Example could be a thief or a bailee. We now have finder and occupants of premises in which the chattel is found. And an occupier of land or a building has superior rights over chattels in or attached to the property, or in cases where they have manifested an intention to exercise control over the building and its contents. Then the courts, before, in relation to finder and occupants of premises, the court considers certain rules. One, the nature of the premises, and second, the state of the premises at the time the chattel was found. In Else versus, we have a case of Else versus Briggs Gas Company. Furthermore, in determining the owner of a chattel, found lying on the land, the court will consider the question of possession. One, in the case of an occupier and a visitor, the occupier's right overrides that of the visitor, except otherwise agreed before the chattel is found. Secondly,
Please,
chattels found on an empty land will be considered based on...
We will read the rest. Go to foundation of the law of lost and found. That is very, very relevant to jurisprudence class, yes.
Okay, I'm there. We even have a biblical quotation, which is Deuteronomy 22, 1-3.
Start with the relevant
the basic
Roman
foundations
concept.
of the law of lost.
Start with the relevant Roman concept.
Okay.
Mm-hmm.
The Roman emperor, that's Justinian, he proposed that property which was intentionally obtained by the owner turned into rex nullis and would thereafter be claimed by any individual who found it. Then one can find the foundational principle regarding the law of lost and found in the Holy Bible, particularly in the book of Deuteronomy. That's Deuteronomy 22.
No. You talk about res nullius. What of res derelictu and occupatio?
Okay. That's rex derelictum, prof. That's that's abandoned by the owner.
Okay. What did Justinian say? Res derelictu is equal to?
Okay. The Roman emperor Justinian further proposed.
Don't read it now. You have told us that res nullius simply means unowned property. Okay?
Yes, sir. Yes, sir.
Res derelictu, a property that was owned but later abandoned.
Yes, by an individual.
Justinian said it is equal to res nullius.
Yes, sir.
So,
okay.
And it becomes the property of the occupatio. That is the person who found it.
Yes, sir.
That's the theoretical foundation. Give us the theoretical foundation in Roman law before you go to biblical corroboration. Yes. What does Deuteronomy 22 verses 1-3 say about finders?
Okay. Generally, if a reasonable and diligent search fails to locate the owner, the finder may retain the item. If the finder appropriates the lost item without making a good faith effort to return it, such behavior is classified as theft. The basic foundation of the law of lost and found are also rooted in the codes of ancient Rome. Not all things, however, not all things seemingly left abandoned fell under this category. Justinian surmised or thrown off a ship in a storm out of necessity. However, not all things seemingly left abandoned fall under this category. Objects could drop out of moving vehicles without the owner's knowledge. Justina surmised or thrown off a ship in a storm out of necessity. In this case, the original owner retained his rights or her right of ownership, and to take possession would be constituted a thief, as theft. Roman law thus began to flesh out some formative distinctions about property ownership, which would subsequently form the basis of the modern Western legal tradition. Now we have possession as a source of property rights. Possession is a property interest under which an individual, to the exclusion of all others, can exercise power over something. Under common law, possession is recognized as a basis for entitlements. Contemporary legal authorities view possession, typically understood as a combination of physical control, which is the corpus, essence of possess, which is animus, as a causative event capable of generating a general property right in the possessor. This right, while not absolute ownership, carries many of the incidents of ownership and exists concurrently with any superior title held by others, such as the true owner of lost goods or a dispossessed landholder. In common law countries, possession is itself a property right. The owner of a property has a right to possession and may assign that right wholly or partly to another, who may also assign the right of possession to a third party. While in civil law countries, possession is not a right, but a legal fact, which enjoys certain protection by the law. For e.g., ownership of a house is never proven by mere possession of a house. Possession is a factual state of exercising control over an object, whether the object is owned or not. We now have types of possession. We have actual possession and constructive possession. Extent of the finder's right. A finder holds possessory title to the property against all persons except the true owner, which was established in the case of Amory versus Ll.M. Also, the case of Briggs versus Hawkesworth. Here, the plaintiff found some banknotes on the floor of a shop and handed them to the shopkeeper, asking him to return the money to the original owner. When after 3 years, the money remained unclaimed and Briggs sought to claim it as his own, but the shopkeeper submitted to the court that he had the better claim as the item was found on his property. We also have the case of Parker versus British Airways Board. We now have reasonable steps to find the true owner. The general relating to the lost or abandoned goods, having acted honestly, acquires a right to possession of the goods as against all other people except the true owner or a person enjoying superior title. A finder, therefore, has the duty of taking reasonable steps to find and return lost items to the true owners and thus become a quasi-bailey of the item. A finder will only acquire an absolute indefeasible title where he is unable to find the true owner, whose title would become abandoned and extinguished at law. We now have distinctions between lost, misled, abandoned property, and treasure trove. Property is regarded as lost if the owner involuntarily and unintentionally parted with it. Then, when we have in misled, this is where the owner voluntarily and intentionally put it in a certain place with the intention to recover it, but later forgot. Then, when we talk about misled property, it's also referred to as forgotten property. Abandoned, we see the case of Lawrence versus State, where a criminal prosecution brought against a barber for stealing a pocketbook left on the table in his shop. The court held that the property was not lost. When it comes to abandoned, a property is regarded as abandoned where the owner voluntarily forsakes possession or where it is left without the expectation of reacquisition. Treasure trove It is a treasure trove where treasures such as gold or silver or other items are buried, concealed or hidden for so long that the owner is probably dead or unknown. Exceptions to the finder's rule,
Is there
right?
any distinction between mislaying and abandoning a property?
Okay. When we talk
Hello?
about, yes, sir.
Yes. What's the distinction between a mislaid and an abandoned property?
Okay.
Okay, so for an abandoned property is where the owner voluntarily forsakes, like you intentionally don't want to have anything to do with the property, or you're no longer interested in it, you don't come around to maybe claim ownership or to make use of it. You've just forsaken it. Maybe the property is now being dilapidated or something of that sort. But a miscellaneous property is whereby the owner must have kept it somewhere, or must have developed the property, or must have purchased the property in the case of maybe a property to buy or something, or does not later now know where the property is located, or does not know in true sense where the investment or the property is generally. So one means that the owner does not want to have anything to do with the property, while the other one means the owner kept it but cannot recall where they kept it, or cannot find it anymore. Maybe effort has been made to find
Is
it, but
there any distinction between mislaying and losing? Is
mislaying
there
and
any
losing.
distinction between a lost and mislaid property?
Yes, sir.
Are we not playing
For
on words?
sir,
What's the distinction between losing a property and mislaying it?
for losing a property, sir, this one means, if I'm to speak in the lay sense, sir, it means that the owner did not even plan on losing it, or did not intentionally lose something. So for loss is, you absent-mindedly do not even know that kind of thing can happen to you. Maybe you bought a property and you do not, in your wildest dream, envisage that there will be any parting of the property. You did not see that it would go to a place that is beyond. Maybe let me just give an example. You buy a property in Lagos State, for instance, and in your wildest dream, you never thought that the Lagos State government was going to come and reclaim the property or something of that sort. So if that should happen, you have lost the
Use
property.
chattels as example. It's better to use chattels.
Okay, so for
things that can be physically possessed, don't use land.
Okay, sir. Okay, sir. So if you buy, let's say, some sort of goods, or and then it might have been shipped in from one of the countries, and before it gets in there, or before it comes into Nigeria shores or thereabouts, the property that you bought must have dilapidated or spoiled, and it is beyond recognition, beyond use, beyond resale, beyond. So in that case, you've lost the property. You did not intend to, it was not your intention that your investment or your property or your charter or anything will go missing, but that has happened. So when that has happened, that's a lost investment, that's a lost property, that's something that cannot even be reworked on. You cannot refurbish it in any way. But a miscellaneous property is where the owner voluntarily and intentionally puts it in a place where they cannot, maybe you're not supposed to keep
Remember,
some. Yes,
he
maybe you're not
can't see
supposed to keep.
somewhere, he can't remember where he kept it.
Exactly. And you has made
That's
effort to
misleading.
try and recall it or find it, but no, nothing. Yes,
Okay.
sir. Thank you, sir.
So how do these different scenarios, how do they affect our topic? How do they affect finder's right? If a finder finds an abandoned item, if a finder finds a mislaid item, or if
Sir,
a finder finds a lost item.
that's where I think the law of some people will say finders keepers, but before the finders keepers play out, I think a reasonable steps should be made or on the part of whoever finds it, to maybe relocate the owner, or send the property to maybe the police station or something of that sort, but whereby effort have been made by the finder to to reconcile the property that has been lost or misplaced or something of that sort to the original owner, and it's impossible, then maybe the finders keepers rule can play into.
Are you sure that in reality there is any distinction between the different circumstances?
Sir, may I come in, sir?
Yes.
Okay,
Come
sir.
in.
For lost, mislaid, or abandoned property, there are three ways we can approach it. For mislaid property, the finder has no rights because the owner of that property, I wouldn't use the word property, I could say purse, or I could say my phone. The owner of that particular phone, let me use phone for instance, the owner of that phone kept it somewhere and unconsciously may have forgotten it there. The owner of that phone may be looking for it at that point in time. So the finder has no right because that particular phone was not abandoned or was not lost. It was mislaid, as the word implies. The owner must have kept it somewhere and unconsciously forgot it or is looking for it. That's mislaid. It happens every time. It could happen to any of us and say, where's my phone? Where did I keep my phone? That does not give a finder the right. And a mislaid chattel or property, usually the owner starts looking for it almost immediately. There is no time that the
So what
finder
is
will
the
not.
duty of the finder in that circumstance?
The duty of the finder is
To spend his money to advertise that I found this phone, this place. So let
yes,
the
sir.
owner come.
That there's no, I don't think because I've had a situation where some people misplace various items or, misplace it, yes, or something like that, and then somebody else, a stranger, finds it. It is out of goodwill that they go to maybe the nearest police station or the nearest radio station to make to draw the attention of the maybe owners to say, okay, you know what, during your announcement, public service announcement session, can you please announce that this thing you don't have to pay any money to register any misplaced or found item at the police station. Neither do you have to.
The best thing is even to leave it where you found it. You can call attention of any authority
That
or a
works
third
as
party.
well. Yeah.
Yes, that I found this phone. It happens a lot. I found this phone. If there is no intention to steal it or permanently deprive the owner of it, let me use that word, you would definitely call attention of one or two persons who may later get it to the owner. But for a lost property, the word lost, the owner may not even go back to that said place. It was not mislaid, it was actually lost. In that regard,
You
maybe
know why
if the
I'm asking this? You know why I'm asking this question?
no, sir.
You know, very often we celebrate people, maybe drivers who find people's things in their vehicle and return it to the people. Okay? By the law, do they really have a choice other than to do that?
No, sir, they don't have a choice. That is the right thing to do.
Now, suppose after making efforts, they don't find the owner, like that case you cited. Who keeps the thing?
The finder's rights come in, sir.
So in other words, the distinction between because you as a finder, you will not know whether it was abandoned. You will not know whether, unless, for example, if you find a valuable item on the dustbin in a manner that you cannot say that it was by accident, that this person doesn't need this, that's why he has thrown it away. You understand? But in most instances, the finder will not be able to distinguish between whether the item was lost, whether it was mislaid, or whether it was abandoned. So it would appear as if the duty on the finder is the same, to make reasonable effort to locate the real owner, so that if from the content of the property itself, the owner is identifiable. Okay? For example, if it is a car and it has a registration number, you should be able to trace the registration particulars. You could be able to use the registration particulars to know the owner. Okay? If it is a bag containing money and the bag also contains some information or like an identity card or something of the owner, or maybe a checkbook or anything that you will use to trace the owner, it's not your place to begin to say, was it abandoned, was it lost, or was it mislaid? You still have the same duty to make effort to find the owner. It is when you don't find the owner, after a reasonable effort has been made, that the finder's right claim comes in. So for me, I don't know whether the decisions make any difference as regards finder's right. It would appear as if in all circumstances, the law does not want you to unjustifiably enjoy another person's sweat.
Sir, but
Yes.
what if the matter eventually gets to the court and the court considers the circumstance in which the item was lost and probably found out that, oh, it was an abandoned chattel? And we all know that if it's deliberately abandoned by the owner, the finder has a right to the chattel. Would that not help the distinction between whether it's mislaid, lost, or abandoned? Will it not help the court in finding whether the finder will have a right to the chattel if the owner brings an action against the founder despite abandoning the chattel and found by an innocent founder?
If he brings the action after a reasonable time, he will.
We are not hearing you, sir.
Most likely to also be affected by being in possession of this thing for more than 6 years now. And six years,
So we can't hear you.
Sir, we did not hear you, sir. Your voice is breaking, sir. We can't hear you.
Originally mislaying the thing or losing it, and now finding it in someone's hand. Okay? Anyway, we are just thinking like members of a jurisprudence class. Can you conclude your paper?
Sir, may I say something, sir?
Yes.
I believe that the general rule is that the finder has a right, except against the real owner of that particular cattle.
Yes. Well, the real owner too has to come within
reasonable time.
Yes.
If the real owner shows to the court that he or she had made reasonable efforts and had even lost interest that they may not see it again, and later they found it, I still believe that the word reasonable may become questionable in that scenario, sir.
Well, we are not in a third class. We are just thinking aloud.
Yes,
We
sir.
don't have to agree. We don't have to agree. Now, what is my own concern in making us to discuss this topic? I will tell you what my concern is. I don't need your part 4. I don't need where you are talking about constitution and all of that. Okay? I think what you have said up to part 3 is all right. Okay? We are concerned mainly with the common law finder's right in the law of tort. Okay? And we are concerned in the jurisprudence class with how can we use it to explain the common maxim that possession is 90% of ownership. And how can we use the defense of Justice T to explain the opposite of that presumption, which is that a possessor can assert right of ownership against everyone except the person with a better title. In between just 30 and finder's right, which are topics in different, in the area of law of tort, we are able to amplify 2 concepts or two maxim or common legal statement. Finder's right amplifies the statement that possession is 9/10 of the law, that possession is 90% of ownership. Just 30, on the other hand, amplifies the view that even as a possessor, with all of the benefit that you get, you must defer to the person, to the real owner or the person with a better title. Do you understand? Hello?
No, sir. No, sir. Please come again, sir.
I'm saying, why are we discussing this topic in a jurisprudence class where we are concerned with concepts and the aggregate right that makes up ownership? We are discussing the topic, even though the two are topics in the law of tort. We are discussing them to illustrate on or elaborate 2 seemingly opposing statements about ownership and possession. The first one, which is that possession is 90% of the law, or possession is 90% of ownership. The second one, which depending on how you view it, is either an opposite statement or a statement elaborating the first one, says that the possessor would assert ownership right against everyone except the true owner. So if you look at the just 30, concept as a defense in law of tort, it is derived from that assumption that yes, if you are in possession of a thing, you have all the right to assert ownership or title or whatever, or property in the thing. But that your right will stop when you have to contend with the true owner. In just 30 now, the person with whom you are contending is not the true owner. but we have been given the two circumstances where he can assert the true owner's right to defeat you. In the first part of your paper, you show us that just 30, we will claim, we will be able, the defendant will be able to plead if he can show that he has the consent or permission of the real owner. Okay? The second one, which is another explanation of the first one anyway, relates to bailment. Bailment is, for example, if a person who has found as or has come in contact with another person his car, okay? The real owner approaches him.
I hear you, sir.
I say, if I'm giving an example of just 30. Suppose a son drives the father's car to a mechanic workshop, directing the mechanic to effect repairs on the car. Suppose the father, who is the real owner, gives the mechanic a counter instruction and tells the mechanic, sorry, deliver my car immediately to my own mechanic. Okay? So if the son were to sue his own mechanic to court for taking instruction from his father, okay? If you were to sue him on the basis that I am the bailor, I am the one who gave you this car to do, you ought not to deliver except upon my order. The mechanic or the owner of the mechanic workshop can defend himself by saying that, look, the person who gave us instruction to deliver is the owner of the car. That's a typical example of just 30 defense. I am right in doing what I did, sir, because I discovered that your father has a claim or a better claim or a title claim or ownership claim to the car. And so when ownership confronts possession, possession has to go. Meaning that your right as a mere possessor of the car is against every other person. I have not done anything wrong in delivering the goods. Okay? So just 30 explains that leg of the presumption that the possessor, okay, the possessor would be able to exercise all rights, including ownership, except against the person with the, whether you call it better title, superior title, or ownership. It is the same concept that has been adopted in trespass cases, where it is said that a person in possession will have a right to sue for trespass. You will have a right to sue any other person for trespass except the person with a better title. So it appears as if that statement or that, can you call it a maxim? It's not a maxim, but rule is what several aspects of the law of tort is amplifying. It is the same rule that is being applied in trespass. It is the same rule that is being applied in just 30 defense when somebody is being sued for conversion or dirty new or other aspect of trespass to goods. Okay? And all of that. So that is what we are trying to emphasize. Okay? That you find the law uniformly explaining concepts, whether you go into the subject area of land or in the area of thought. Okay? So you can take down this. You can take down this. Hello?
We can't hear you, sir. Your voice is going on and off, sir.
We
Okay.
can
Yeah,
hear you.
we
Sir.
can hear you now. We can hear you now. You said we should take it down. Thank you, sir.
Okay. Take this down now. Between the common law treatment of the defense of just T, between the common law treatment of the defense of just T and finder's rights, in the law of torts, is a demonstration. Not only that title or ownership, is superior to possession, even if possession is as good as title, when no title owner has shown up. So you can use this to discuss their paper, okay, and see how much information do you get there to answer this, okay? Are we all right?
Yes,
Yes,
sir.
sir.
Yes,
Yes,
sir.
Yes, sir.
Thank you, sir.
Thank you, sir.
Hello, are we all right? Okay, so let me leave. I have quite a number of calls. Some of them are very important that I want to pick. So let me pick this particular one.
Okay, sir.
Okay, sir. Go ahead, sir.
Thank you, sir.
Thank you, sir.
Thank you,
so
sir.
much, sir.
Have
Everybody
a
is
lovely day,
was
sir.
present from group 6, sir. Thank you.
We are all present, Group 6. Thank you, sir.
Class rep, is there any information for us before we exit?
No information. Next class, Prof will communicate to us to me before next week Tuesday, whether it's going to be virtual or physical.
Please let's
So
convince him to make it virtual as always. Thank you so much.
We have only one more topic. We have only
yes,
one more topic.
under
to take now.
possession, Group 7.
That is group 7
We
for
have
today.
adult possession.
Oh yeah,
Adult
Group
possession is
7.
also very important.
Group 7, please. So
Yeah,
start
that is group
presenting.
7.
And Tuesday, let's do Tuesday virtual, and let's
Okay.
start property. I mean, theories of thought and contract, physical. Upper
Okay.
week.
No problem, sir. Thank you, sir.
Thank you, sir.
sir.
Okay, so that means we are done with the possession, everything
Thank you,
on
sir.
possession.
Thank
Group
you.
7 have not presented. What about the advanced
Sir, Group 7
possession?
has not presented. They are under their adverse possession.
He said we'll
That's
take
why
it
Prof
next
says I will
week.
take
You're
it next
welcome.
week now. That's what he said.
Said.
He said,
Okay.
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 That's what Prof said. Next week, yes.
he said we'll take it next week, then
He said
we'll go
group
to the
7.
next
Group 7
one.
is online. Then group 8 is physical, upper week.
No, that's not what he said.
That's not what he said, Joe.
That's not what he said.
That's not what
That's not
he
what he
said.
Mo
said.
fẹ́ lọ pàdé ẹnìkan
Okay,
lẹ́nu
what should
géètì.
we do?
Mary,
Kò ní ìdí kí n tẹ̀lé yín lọ gan sef.
Yes, please.
it's precious, so I'm in class. So
No problem. What we
People
need
should
now,
stop
next class
putting.
is
People
virtual.
should stop crowding the platform,
Ẹnìkan
because
bá
it
mi
will not be
pé somebody
recorded.
and he doesn't
It's only
pick.
on this
After
chat
gbogbo
box that is going to be recorded. I don't know why people keep putting
mo
your
fẹ́ fẹ́ nọ́mbà ẹ̀
screenshots
tọ̀.
of it. It's not going to be collated. If you don't put your name in the chat box, I can't do anything about it, because it's a recorded lecture.
Please, Mary, write a proper notice and put on the group chat so they will stop doing that.
I should
Not
do
all
what?
of them.
I should do what? I announced it and I posted it on the platform. Nobody still
You can still do it
people
now.
kept on doing what you wanted.
Sorry, no, sorry.
Let us cooperate with our class rep. We can still do it. I have done my own.
But she announced it before time now.
But she has announced it now. She even
I announced it and I even posted it. Can you people continue?
No,
I have
please.
even
We can type
Are you going
your
to do
name
anything
and your
about
number.
Talking at the same time.
God bless you. God bless you. Let us cooperate. Please.
Everybody should try
You guys
and
should
obey
stop stressing
instructions,
the
please.
class rep, please. It's not easy to be a class rep.
Please, let us cooperate.
And
Thank you.
we all appreciate. We appreciate her.
God bless you. Class rep, thank you.
My governor, I celebrate you. Thank you so much.
Anyway, thank you, Genevieve and Chinelu. God bless you people.
You will not tag Gadebo.
You will not tag me.
You're welcome, my able class
You will not
rep.
tag me.
Actually, you will not tag your friend. You will not tag your best friend.
You know your wahala is too much. I have bye.
Okay, thank
Tag
you.
me now.
They're going
Thank
to
you.
put it
Tag
up.
me.
So let the
I will call you to find out what prep schedule. Thank you.
okay,
Yeah.
no problem.
Òun fúnra rẹ̀ ó lè ta ẹ̀ bá kan. Àti ó lè wọnú mọ́lú àyè. Kò lè wọnú mọ́lú.
Mo rò báwa máa gbà ń bẹ̀ ní àwọn tó máa gbé wọlé. Ní òun ẹ̀yin lè máa gbà. Kò lè fún alókùn yẹn, fún afọ alókùn sọ. Bẹ́ẹ̀ náà bìbá kíkà lọ sí dáhùn méjì bá àwọn mọ́tò àlè rí bẹ́ẹ̀. Ó lè máa bọ̀ fún wa bóyá kò tó fi ṣiṣẹ́ díẹ̀.
I don't know whether Prof has left.
Prof is still on. He's still on, Mary. Okay.
Has
Can
Prof
still-
left?
It's-
Please, class, has Prof left?
Prof is
That's
attending
great,
to
Abby.
his calls. He's attending to his calls.
Okay, let's wait and see if we can take group 7. No, I mean, I don't
No, we're
understand.
not taking group
We are
7.
not taking
Prof
group
said
7.
that- Prof said that we are taking it next week. After
It's
group
next
7,
week.
then we will now take other the other aspect that he has actually grouped, the one on the thoughts. I'll communicate with him during the week and he will confirm. Then I'll revert to the platform.
Thank you. That was good. We'll be expecting to hear from you.